In this episode, we're going to look at criminal law procedures. But first, let's talk about what we mean by crime. Crime is when a law is broken, and it's an act that hurts people or society. Each state has its own set of penal codes. These are criminal laws. Breaking one of these laws leads to a punishment. It could be a fine, it could be jail time, it could even be the death penalty, depending on how severe the crime is. Now there's two basic types of crime, misdemeanors and felonies. Misdemeanors are minor crimes, think shoplifting. They're usually punished with fines, community service, but can be sentenced up to a year in jail. Felonies, on the other hand, are much more serious. Think about murder or bank robbery, kidnapping, and they can be punished with over a year in prison. Of course, the ultimate punishment in our system is the death penalty. Now, punishment is something that is protected by the Eighth Amendment. We cannot use cruel and unusual punishment in our system. It's expected that a judge fit the punishment to the crime. So the sentence, the punishment that the judge is putting out, is individual by case. So there's going to be a big difference in punishment for somebody who is stealing a candy bar and compared to somebody robbing a bank. Now, even with this said, most sentences are reduced. Prisoners can be granted early release from prison. This is called parole. When a person is let out on parole, they're still monitored by the government. They're given a parole officer that they have to check in with on a regular basis. Now let's look at the actual case procedures for criminal law. Now you need to remember that because a crime is being committed, it's going to be the government, or what we call the prosecution, that begins the criminal case process. First off, a person has to be arrested for committing a crime. If that person is not caught red-handed in the act by the police, then a judge will issue an arrest warrant after the police obtain enough evidence. Think of it this way. We'll go back to our example of a bank robbery. If the robbers are coming out of the bank and the police are there and they catch them right in the act, then obviously they've been caught. But if the robbers get away and it takes weeks for the police to solve the crime, they're going to take that evidence they've found to a judge and ask for an arrest warrant. Then they're going to go arrest the people they suspect of being the bank robbers. Once they're arrested, that process includes our Miranda warnings. The police have to Mirandize the suspects, or else they're not, their case could end up in appeal and they could be given a new trial. So the police must Mirandize the suspects. Once they've been arrested, they're taken to the police station. Here they're going to be booked. They're going to be photographed and fingerprinted during the booking. The photograph, of course, is called a mugshot. Next up in our system is what we call a preliminary hearing. At this stage, the suspect is brought before a judge to be charged. The prosecution has to prove reasonable cause. They have to have evidence to charge the person with a crime. The judge's job is to explain the charges to the accused and to provide them with a lawyer, what's known as a public defender, if they can't afford one on their own. Public defenders actually work for the government, just like the prosecution does, but they're on different teams. If the crime is a felony, then the judge will set bail. What bail is, it's money to ensure that you return to court. If you can't put up the bail, then you're going to have to wait in jail until your trial. So bail is set so that you come back when you need to, when the next hearing is scheduled. Now bail can change. Bail can be huge amounts of money depending on the crime, down to maybe a couple hundred or a couple $1,000s. Once bail is set, that person, though, is free to go home once it's been paid. They're going to schedule another hearing, and at this next hearing is where the suspect will plead guilty or innocent. Now, it's a different story with the preliminary hearing if there is a misdemeanor involved. If it's a misdemeanor only, then this preliminary hearing is where the suspect enters their plea. They can either plead guilty, and if they do that, they're going to be sentenced right there and then. If they plead innocent, then the judge is going to schedule a trial date. Now, next up is the indictment for a felony. The grand jury, or like a jury of people, or the judge are going to meet to see what evidence the prosecution has against the suspect. After the hearing about the evidence, the suspect will be indicted and the process will move on. If there's not enough evidence, according to the grand jury, though, then the process stops and the suspect is free to go. Now, let's say the person has been indicted. After that comes the arraignment. This is when the person actually pleads innocent or guilty. At this step, the suspect can also accept a plea bargain. This is where they plead guilty to a lesser charge. For the most cases, they end through a plea bargain and we stop right here. If they accept the plea bargain, the judge is going to sentence them and give them their punishment right at the arraignment. Now, let's say the person pleads they're innocent. Then a trial is going to be scheduled and put on the court's docket. Of course, the docket is the list of trials that are coming up for the judge. So now we move on to the trial. At the trial, for a felony case, the defendant gets to choose if they want their case heard by a judge or by a jury. The vast majority of defendants pick to be having their case heard by a judge. They would rather one person make a decision compared to 12 people. If it is a jury, though, the prosecution and the defense are going to interview potential jurors and they're going to choose which ones they want on the jury. Up next, once the jury has been seated, we're going to have the lawyers give their opening statements. This is where they kind of introduce the case. The prosecution always goes first because it's their job to prove beyond a reasonable doubt that the defendant is guilty. Remember, in our system, we have the presumption of innocence. You are innocent in a criminal law trial until they prove to the jury that you are guilty. So the prosecution is going to present its case. They'll call witnesses to testify and present any physical evidence. Now, the defense gets to cross-examine witnesses. They're trying to discredit what's being said and what evidence is being presented, basically poke holes in it. The defense then gets to present its case as well. And likewise, the prosecution gets to cross-examine those witnesses. Finally, when all the testimony has been given, both lawyers, first the prosecution, then the defense, are going to give their closing arguments. Basically, it's their conclusion and wrap up their cases. Once this happens and the closing arguments have been given, the jury is then going to deliberate. They're going to meet, just them, and discuss the trial in private. Then they're going to vote. For a person to be found guilty, all 12 jurors must vote a person guilty. It has to be unanimous. And the jury can take as long as they want to fight about this. They can go for hours, they can go for days. If they can't make up their mind, it's called a hung jury. And a mistrial is called. That means there's no decision made. In the case of a mistrial, the prosecution has to decide if they want to try the case all over again or just stop and let the person go free. If the verdict is not guilty, then the defendant is acquitted and set free. On the other hand, though, if they're found guilty, the judge will then sentence them. Those found guilty can always appeal their case. But if the prosecution is not happy, they cannot appeal if they lose. The Fifth Amendment protects us against double jeopardy, being tried twice for the same crime. Okay, so that is our criminal legal system and the procedures in which we use.